Dear participants, we will wait for 2 more minutes to let people to come and we will start then. Thank you very much. Your Excellencies, dear participants, I would like first of all to thank all of you for coming for this side event to discuss the impact of unilateral sanctions on access to justice and to an effective remedies. As you are aware, I prepared a report to the Human Rights Council, which was presented in September, focusing on the access to justice in international law and the impediments caused by unilateral sanctions means of the enforcement and overcompliance to this problem. Unfortunately, the problem didn't disappear, and we face it today. The report which was presented was able to address only some aspects and to elaborate on some elements of the impediments we are facing in the sphere of due process and in the sphere of fair trial, as well as challenges caused by the broadening use of unilateral sanctions. Some aspects of the problem has also been addressed in the guiding principles and the commentary to the guiding principles we all have discussed at the conference in November last year, which I believe was extremely successful. I took into account all the remarks which have been done by all the participants and finalized both the guiding principles and the commentary, and you can see them both online fully. At the same time, I have to say that everything what has already been done in this sphere is not enough, upon my opinion. There are many problems. Access to justice for those who are directly affected by unilateral sanctions. Access to justice to those who has not been even mentioned by the sanction and regulation at the same time, whose rights are affected incredibly. We shall discuss the issue of the right to the meaningful remedy, which is broadly recognized by everyone. We shall discuss the issues of due process and fair trial. We shall discuss due diligence obligations of states, which, in accordance with international law, are obliged to use all possible means to make sure that basic human rights, including the right to fair trial and access to justice, are not violated, including extraterritorially. I need to say that we pay lots of attention to the issue of access to justice in many UN documents. I would refer not only to the treaty bodies, I would refer to multiple reports and non-binding documents developed by the UN agencies, UN specialized agencies, regional organizations all around the world, which clearly reflects that their access to justice and right to fair trial are constituting customary norms of international public law, which provide not only the right to access justice on its own, but also ensure that the people have the possibility to protect their rights via reaching out to the competent bodies. However, protection of those who are affected by unilateral sanctions means of the enforcement and over-compliance are not regulated yet. And we are talking not about a few persons which occasionally appear to be bad guys or appear to be bad guys. We are talking about at least 30% of population around the world living in the countries affected by unilateral sanctions. Additionally, we are talking about populations of third countries as well as countries which impose sanctions, taking into account that these people also are subjected to secondary sanctions, criminal, civil, customs, administrative charges for circumvention, alleged circumvention or assistance in alleged circumvention of sanctions regimes. And quite often, they face serious challenges to access justice and to protect their rights. The problem of the impact of unilateral sanctions means of the enforcement and over-compliance on the access to justice can be addressed from different perspectives. From the perspective of states which developed sanctioning legislation or those who are under sanctions and try to protect their own nationals and businesses. From the side of lawyers, who quite often might be deprived of the possibility to represent their clients fully as soon as they cannot reach out the court to represent the case, or those living in the sanctioning country, the ability of which to represent their clients is limited as well by the current legislation. It might be presented from the perspective of businesses, as soon as in many cases, they are already developed a number of fraud mechanisms how to receive money and then to refer to sanctions in order not to perform the contract and not to pay money back. It can also be addressed from the side of individuals who are directly designated for something what doesn't even constitute a crime, with no access to the evidences or any proofs that they did something wrong. Or especially from the perspective of the general population, which might be probably haven't even heard about unilateral sanctions, but at the same time, rights of which is terribly affected by all the sanctions imposed on specific country. I'm very happy today that we managed to invite lawyers coming from different countries and with different backgrounds who will try to represent the position about the impact of unilateral sanctions and means on the enforcement on their ability to represent their clients in the face of sanctions-related cases or cases having something to do with unilateral sanctions. We have today 3 amazing professionals whom I will ask to stay within the limits of 6 minutes. 2 of them will participate online, and I would appreciate if you use your ear devices to hear them. And there will be a possibility afterwards to intervene and to provide your position as well as to ask questions. I'm asking our panelists to stay within 6 minutes time in their presentation. Then for states who will demonstrate the interest to take the floor, I will ask to stay within 3 minutes limit. If we have time afterwards, I will be happy to give the floor to non-state actors. Therefore, please be ready to demonstrate your interests afterwards. And at the very end, I plan to give the possibility for our panelists to have a feedback within around 1 minute or a minute and a half. With all that, I would like to give the floor to Dr. Fátima Rodríguez, who is a lawyer of Lupicinio International Law Firm, who is presenting online.
Good afternoon, everybody. As head of the International Trade and Sanctions team at Lupicinio International Law Firm and PhD on criminal law by the Complutense University of Madrid, it is a privilege to be again before the United Nations to address the effect sanctions have on restricting access to justice. Access to the courts of law is a fundamental human right insofar as it materializes others, such as the right to effective legal remedies, and in a way upholds all rights because often they can only be enforced or guaranteed through the courts of law. Consequently, international sanctions that ban designated persons from appearing before courts to defend their rights are foreign to the most relevant sanctions regimes, as they would be completely inadmissible in a rule of law state, especially if it entails a barrier to challenge the sanction or their designation. On the 2024 rulings in cases T797/22, T798/22, and T828/22, the General Court gathered in Grand Chamber rejected the appellant's annulment plea for the measure restricting lawyers established in the European Union from providing legal advice to the Russian state and Russian entities. However, case law derived from these rulings makes it absolutely clear that the prohibition did not apply to litigation in judiciary, arbitration, or administrative proceedings. Indeed, the General Court found that Article 5N5 and 6 of Regulation 833/14 allows for advice, defense, and representation by a lawyer in the context of the right to effective legal remedies as laid out in Article 47 of the Charter. The implication is that such services are permitted only if they are related to litigation proceedings. However, this extends also to assess the client's situation before a potential claim. It allows engagement in a preliminary assessment in order to determine whether the service mandates are strictly related to the promotion or even to the prevention of litigation proceedings. In the scope of this last provision, lawyers may address the legal situation of entities established in Russia and provide legal services to them. From the foregoing, we must conclude that these international sanctions do not, in paper, limit access to justice and the right to a lawyer, at least as strictly interpreted from the Charter of the EU. However, effectively, a natural or legal person subject to international sanctions may often face significant de facto barriers when pleading a claim. Firstly, a person sanctioned by the EU may face serious prejudice and expose their lawyers to ill repute and heavy-handed scrutiny in the proceedings. This bias is not helped by aggravations in between the lines of sanction narrative against designated persons. Secondly, this risk usually results in higher costs for the designated person in order to compensate their legal team for their exposure. Thirdly, clearly distinguishing between services related and not related to litigation is rather difficult as ultimately almost every mandate can result in a claim. In practice, the precise point of which services become litigation related is not neatly defined. Finally, we must address the over-application of sanctions. In short market, actors often apply restrictive measures excessively in order to guarantee compliance, and their application goes even farther than what regulations provide due to misinformed fear of infringement. For example, it is rather common for banks to refuse to carry out transactions with sanctioned countries even if the transactions are not forbidden. This hinders lawyers from being paid for the services they have rendered to sanctioned persons, and therefore dismays them from providing such services. This hostile attitude, encouraged by European states and institutions, effectively makes it difficult for persons subject to sanctions to access the courts. Therefore, the measures stops them from enforcing their fundamental right to effective legal remedies. To conclude, access to justice is limited to access to the courts. European sanctions, as provided for in the instruments by which they are issued, do not limit the right to effective legal remedies. However, the reality of the legal market and the pressure exerted by European states and institutions on legal operators through their sanction narrative does lead, by way of consequence, to real restrictions on access to justice. Before I go, I would like to thank you, the United Nations, again for having me. These conversations are steps towards building a better world, and it's a great honor to be allowed the opportunity to participate today. Thank you very much.
Thank you very much, Dr. Rodríguez. And now I'm happy to give the floor to Mr. Michael Swainston, barrister from the Greek Court Chambers. So please, the floor is yours.
Madam Rapporteur, ladies and gentlemen, I'm an English barrister. I decided to be an English barrister at age 11. And one of the things that attracted me to the profession from the outset was the cab rank principle. The idea that a barrister has to take any passenger, any customer, however unpopular, to whichever destination, however unpopular that may be. It struck me as a noble thing to do, to commit oneself to the idea of justice via fearless and independent advocacy for any party. So I felt especially the enormity of what happened in the United Kingdom in 2022, when the last round of sanctions was introduced. And in particular, when Liz Truss, then Foreign Secretary, suggested in Parliament that London lawyers, if they worked with Russians, prominent Russians, were white-collar collaborators, and suggested that, well, a backbencher suggested that such lawyers should be named and shamed. And lawyers acting for Russian clients were warned by Whitehall's sources that they may be penalized. At the same time, next slide, we had constitution of a task force, probably with government encouragement, at Sussex University, where a distinguished lawyer announced that the right to representation in civil matters was not clearly established, like the right in criminal law. And somebody with the interesting title of Professor of Anti-Corruption Practice argued that there was a group of clients who should not be represented by lawyers. Quite extraordinary against the legal culture in which I grew up and in which I aspired to be a barrister. So next slide, we might have expected that things would get worse, because Liz Truss, former Foreign Secretary, became Prime Minister, but then happily the lettuce supervened. And you may recall the tabloid press established that she had a shorter political lifespan than a Tesco lettuce, staying in post for only 49 days. So perhaps we can move to principles with greater claim to longevity. UN basic principles on the role of lawyers, calling for everybody to have access to proper legal representation. And next slide, guaranteeing protection of lawyers when they do their job, not threatening sanctions against them for doing their job. Next slide. And now we've got our own guiding principles with much the same content. Next slide. You can read them at leisure, but they say essentially the same thing. Lawyers must be allowed to do their job, and they mustn't be intimidated when they do it. Now, contrast, if we may, next slide, the position in the UK. I'll take this quickly, but the law stops lawyers acting for designated individuals and for entities controlled by them. And the UK government, in my direct experience, uses this to obstruct representation in important cases. In my case, including representation of Russia in the International Court of Justice in a case that Russia won last year. There are general licenses to escape this regime. Next slide. And next slide, please. Next. And next. And next. Next slide. Next one. Next. 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 But the problem is that these general licenses do not work. Next slide. And next one. The problem is that there is an overall fee cap for all lawyers and experts on a case. So no individual barrister knows in a big case whether that cap has been reached. And so acting for a designated client or somebody potentially controlled by one entails the risk of criminal prosecution and even imprisonment. Now, how many barristers are going to do that? Not many is the answer, and the result has been extremely unfortunate legal results in London. Next slide. The reason is that there has not been sufficient representation to mount proper challenges to the sanctions regime. There have been cases where suicide risk of children has been said to be outweighed by benefits of sanctions that have not been defined, articulated, or proved. And for example, with Russia sanctions, there's never been proof that designating a mother and daughter when the daughter is ill and vulnerable could have any effect on Russian decision-making at all. Next slide. Hence, in the Khan case, that result. So, where do we go from here? If we go to the last slide, the answer is we should have faith. I have faith that there is a continuing tide, irrepressible tide of justice, which will wash away the injustices of sanctions. Sanctions have a shelf life, justice does not. And it's entirely likely that those who commit their countries to sanctions now will in due course bear the consequences, which include massive liability in investor state cases. Thank you.
Thank you very much, Mr. Swainston. And now we are moving to our last panelist, Mr. Alexey Anischenko, who is the partner of Anischenko Laptev, and he will talk about the challenges faced in the course of international arbitration. So, Mr. Anischenko, the floor is yours.
Hello, can you hear me well?
Yes, we can hear you.
I'm sorry, can you see the slides on your screens now?
No, we can hear you, but we do not see the slides.
Okay, let me try again. Is it working now?
Good.
Okay, then once again, good afternoon from Minsk, Belarus, dear Professor Douhan, dear colleagues. First and foremost, I would like to thank the Special Rapporteur and her team for their great work and for the opportunity to make another small contribution today by informing the Special Rapporteur knew about certain activities undertaken by the Russian Arbitration Association and its members, including myself, to respond to negative impact of unilateral coercive measures, which for ease of reference I will call sanctions on international arbitration and eventually access to justice. Such an impact has been addressed by the Special Rapporteur, particularly in Section 3E of her already mentioned today latest report submitted to the UN General Assembly. All those observations are indeed hold true until today and must not be ignored by arbitration community if we want to preserve international arbitration as fair and efficient mechanism for resolution of international disputes. A lot has been already said and published regarding the impact of sanctions on arbitration, which is clearly negative. There might be different angles how you look at this phenomenon, different scenarios and different classifications. I would simply say that the impact is very comprehensive and can be divided into three big chunks, starting from commencement of arbitration and ending with the problems the parties face at the recognition and enforcement stage. In one of our first cases of that kind, our client, major Belarusian industrial, faced abrupt contract termination with reference to sanctions and decided to pursue claims at the LCIA, which was the stipulated venue in the arbitration agreement concluded between the parties many years ago, and even despite the client was not even listed at the time and was able to engage with the quite a famous arbitration boutique in London, and they even paid the retainer successfully from the Belarusian bank, and the money reached the UK bank. Still, the money was not ultimately released to the UK lawyers and returned back to client, minus substantial commission for compliance checks, which results were never made available. But even if one is successful with launching arbitration, still, it is rather difficult for the sanctioned party to rely on neutrality, impartiality, and equality. Even if there is still a chance to get a reasonable opportunity to present your case, it's certainly not an equally reasonable as compared to the non-sanctioned party. And let me be clear here, I'm not arguing it is impossible for the sanctioned claimant or respondent to win the case, not at all. There are reported cases when arbitrators stood firm behind the law and fairness, even when sanctioned respondent was not able to defend its case or simply refused to participate and didn't appear before the tribunal, considering all the obstacles. However, extensive application of public order, direct prohibitions to perform obligations towards sanctioned entities, even if confirmed by the award, often makes the letter worth not more than a paper on which it was printed. In 2022, Russian Arbitration Association conducted its second study on the impact of sanction on commercial arbitration, which revealed many worrying trends. By way of example, 21% of almost 200 respondents, half Russian, half foreign, reported on refusals of arbitral institutions to commence or continue to conduct cases because of sanctions. Almost 40% reported cases when arbitration institution refused to receive payments from sanctioned parties. Almost 20% reported a situation when arbitrators refused from their mandate, either accepting the appointment or continuing to act as arbitrator. And 20% reported that tribunals rejected claim fully or partially because of sanctions. In light of that, many started to consider using ad hoc arbitration and instead of institutional one, and referring to lex mercatoria in their contracts instead of national laws. For obvious reasons, sanctioned states couldn't stay apart and made rather bold countermeasures like the ones currently implemented in Belarus, which are basically twofold. First, suspending enforcement in favor of residents from unfriendly jurisdictions, and secondly, establishing exclusive jurisdiction of Belarusian state courts over the disputes related to sanctions and empowering those courts to issue anti-suit injunctions in cases related to sanctions. And as you might be well aware, the similar measures were implemented by Russia according to the so-called Lugovoy law, which practice is even more straightforward and has already provoked countermeasures or anti-suits from sanctioning states, which resulted in massive jurisdictional battles, many of which are still pending. Naturally, arbitration institutions try their best to continue their business as usual and reassuring their users in their availability and neutrality, but their powers are obviously limited. And they cannot simply ignore the national laws and national imperatives. Therefore, most of the arbitration institutions located in the countries imposing or supporting sanctions confine themselves with rather soft practical notes or public statements like the ones you can see on the screen. So as my colleagues from Mansur's law firm in Russia nicely portrayed that, nowadays arbitration practitioners affected by sanctions live like in the famous Russian fairy tale Kolobok, facing difficulties in arbitration, starting from instructing the councils and up to seeking license and permits to collect the awarded amounts if we were successful with our claims. And of course, the arbitration community has to say its own word, and sanctions immediately became a very hot topic for debates at seminars and conferences. But the problem is that most of the talk is about the impacts we have just discussed, but rather little constructive proposal how to deal with those problems had been made. In that regard, to those who are interested in the subject, I would refer to probably the most comprehensive practical guide, which was released in 2023 by the International Association of Lawyers. At the Russian Arbitration Association, we reflected on the results of the survey, which I previously mentioned, and noted the growing interest of arbitration users to ad hoc arbitration lex mercatoria, and came up with the idea of SAP, the Anti-Sanctions Arbitration Protocol, which consists of 2 documents, which you can download using the QR codes. Basically, those 2 documents are the protocol itself and the arbitration declaration, and in its essence, it's an opt-in supplement to the Unilateral arbitration rules, aimed at assisting the parties to reinforce an access to justice by choosing in a transparent manner a point in authority, place of arbitration, place of hearing, currency of payment, and of course, neutral arbitrators who are not affected or least affected by sanctions. Now you see the draft abbreviated arbitration clause, which the working group suggests for the users to implement in their international contracts, which performance might be affected by sanctions. The SAP is a work in progress, and the idea and the first draft were publicly released by the drafting committee on in October last year in Casablanca in Morocco, a venue which is nowadays quite often used as a neutral one. And upon initial comments and intensive internal discussion in November during the Dubai arbitration days, the second current draft has been released and opened for public debate. We hope that with the feedback collected during the year, we will be able to finalize and publish a final document by the end of 2025. And Vladimir Hvaley, the chairman of the board of the Russian Arbitration Association and the former deputy president of the ICC International Court of Arbitration, and the man behind the idea, always starts his presentation about the SAP with the story of Alabama arbitration. And with his permission, I do it today at the end of my submission. Unfortunately, I couldn't make it to Geneva today and to be with you, not least because of the logistical hurdles created by sanctions, but otherwise I would certainly visit the town hall and the Salle d'Alamaba and pay tribute to the arbitration, which served as a source of inspiration also for the drafters of the SAP. Frankly, it was rather difficult, if not impossible, to seriously consider something like Alabama arbitration when we started our work on the SAP. Now it is definitely less impossible, And I hope that with joint efforts, including the Special Rapporteur's endeavors with the guiding principles at the UN level, we are getting back on track and restoring gradually the image and popularity of international arbitration as the most efficient means of resolving not only commercial, but also investment in interstate disputes peacefully. Thank you very much for your attention. If any questions, I'm happy to respond. Thank you.
Thank you very much, Mr. Anischenko. And now I would like to propose the participants of this side event to demonstrate the willingness to take the floor. Thank you very much. I see the representative of Cuba. So please, the floor is yours.
Thank you very much, dear Special Rapporteur, dear panelists, dear Damianos, Excellencies, distinguished colleagues. We deeply appreciate the invitation to this parallel event. I understand that some NGOs are trying to connect from Cuba, but due to the use of Zoom platform, there are some difficulties. As you know, UCMs also apply to these kind of things, and we have denounced that for a long time now. Unilateral coercive measures as instruments of political and economic coercion violate the Charter of the United Nations and international law. They constitute a transgression of international trade norms and barriers to the full promotion of human rights in the victim countries. From Cuba's perspective, we should not equate unilateral coercive measures with the term sanctions due to their illegal nature. No state has the right to impose sanctions individually. Only the United Nations Security Council can do so, and only in response to a threat or breach of peace or an act of aggression. Likewise, we point out that the legal responsibility and the obligation to provide individual and collective reparations for the imposition of UCMs rests solely and entirely with the states that impose them. Such responsibility should not be transferred to victim states or to other entities of the international system. Dear colleagues, we reiterate our reaction to the economic, commercial, and financial blockade of the United States against Cuba. The blockade must cease immediately and unilaterally, as it has been unilaterally imposed and applied for more than 60 years. The blockade is a flagrant, massive, and systematic violation of the human rights of our people, to which it has caused quantifiable accumulated damages of $1.5 trillion. The multiple impacts of the blockade on the human rights of the Cuban people have been further reinforced by the arbitrary and unjustifiable inclusion of Cuba in the State Department's unilateral list of alleged states sponsors of terrorism. We appreciate the efforts of Special Rapporteur Alena Douhan and other Special Rapporteurs to publicize the dire consequences of that list. We reiterate our solidarity with our brotherly countries that are also victims of illegal unilateral coercive measures. I thank you very much.
Thank you very much. And now I'm giving the floor to His Excellency, the Ambassador of Iran. Please, the floor is yours.
Madam Special Rapporteur, distinguished panelists, I would like to express my sincere gratitude to you for addressing this critical and highly legal issue. The detailed presentation today has shed light on the serious implications of UCM on access to justice and the rule of law. UCM fundamentally undermine the principles of due process and fair trial. They create barriers to accessing independent legal representation, impose arbitrary financial restrictions, and obstruct the enforcement of legal decisions. These sanctions often result in overcompliance, where legal and financial institutions, fearing secondary sanctions, deny services, even when legally permissible. UCM operates through a complex web of national and regional regulations that impose restrictions on legal transactions. The European Union's Regulation 833/2014, for instance, has created significant obstacles to legal claims involving Iranian entities. This regulation has led to cases where international arbitration institutions refuse to hear disputes related to Iran, depriving Iranian claimants of their right to legal redress. Sanctions also place direct limitations on the legal profession. Lawyers representing sanctioned individuals or entities face severe restrictions, including the inability to receive payments for their services or fear of penalties under national sanctions laws. Many arbitration institutions located in jurisdiction affected by US sanctions require special licenses to process cases involving Iran, increasing costs and delays. These bureaucratic hurdles obstruct legal professionals from fulfilling their duties and threaten the fundamental principle of equal access to justice. Additionally, sanctions listing and delisting procedures lack transparency and due process guarantees. The states and organizations often impose sanctions without clear criteria, making it difficult for affected entities to challenge their designation. The process of removal from sanctions list is often lengthy and opaque, leaving entities in a state of legal and economic uncertainty at a broader level. These challenges raise serious concerns about accountability. Sanctions are often imposed without mechanisms for appeal or review, violating fundamental principles of justice. The international community must work to establish clear legal frameworks to ensure that access to justice is not compromised by political considerations. We call for an end to these unlawful restrictions. We urge all international bodies, including the UN, to take concrete steps to ensure that access to justice remains a fundamental right, free from political interference. I thank you.
Thank you very much, Your Excellency. And now I'm giving the floor to His Excellency Ambassador of Venezuela. Please, the floor is yours.
Thank you, Ms. Rapporteur and dear panelists. We are grateful for the invitation to this activity and greatly appreciate the efforts of Special Rapporteur Alena Douhan within the framework of her mandate. This year, we will mark the 80th anniversary of signing the Charter of the United Nations. Unfortunately, we will commemorate this date in a context marked by major global challenges threatening humanity's existence. Among these challenges is the vile, excessive, and ever-increasing application of unilateral coercive measures as weapons of war, extortion, and economic and political pressure that have a tragic impact of the human rights of the people who suffer from this nefarious practice of the part of the US and the European Union. We value this space that allow us to deepen the analysis of these criminal measures' impact on access to justice and due process. We reject using sanctions against lawyers and judges, including national and international courts, as a form of threat and intimidation. As coordinators of the Group of Friends in Defense of the Charter of the United Nations, Geneva Chapter, Venezuela reiterates its support to continue developing joint actions with the special rapporteurs, such as the last conference on sanctions, business, and human rights, which brought about a space for inclusive and diverse debate by presenting specific documents of the matter. We will continue to uphold the principles of the United Nations Charter with force and conviction, and make a strong call for the end of all unilateral coercive measures that undoubtedly represents crimes against the humanity. Thank you very much.
Thank you very much, Your Excellency. As soon as I do not see any plate notes from the side of states, I move into non-governmental actors. Please, the representative of EPLO.
Governmental. I'm Ambassador Papadakis, representing the European Public Law Organization with observer status in the UN and other organizations. Let me start by thanking the Office of the High Commissioner and Mr. Serafides for organizing the side event, and also the panelists for their insightful comments and analysis. I can only imagine what kind of rides Mr. Swainston had in his career as a barrister. Well, I have three questions, actually. The one relates to the effectiveness of sanctions. Do they vary according to subject and the country they're imposed on? The second one is whether it is true that the most effective part of the sanctions is in the short run and that they tend to weaken in the long run. The third question has to do with a comment by Mr. Swainston about the cap on fees. I didn't particularly get exactly what that was about. Thank you very much.
Thank you very much. Please, the floor is yours.
The special reporter, speakers, and estimate colleagues, my name is Boyi, a researcher at the Human Rights Institute of South University and associate professor at its law school. Unilateral sanctions pose serious challenges for Chinese enterprises operating globally. These measures not only disrupt trade and investment, but also create legal uncertainties. Many companies find themselves caught between conflicting legal obligations. Complying with sanctions may violate domestic laws, where non-compliance risks severe penalties abroad. More importantly, sanctions business often struggle to access justice. Financial restrictions make it difficult to hear legal representations, and in some cases, they are even barred from court proceedings. This undermines the fundamental principles that justice should be available to all, regardless of the political considerations. We urge the international community to ensure that sanctions do not deprive business of their right to fair legal remedies. Access to justice must remain a cornerstone of international law. Thank you.
Thank you very much. Please, the floor is yours.
Is it working? Yeah. Thank you very much, distinguished reporter and all speakers for your sharing your insights. I'm NGO member from Azerbaijan. As you know, occupation and ethnic cleansing of about 20% of Azerbaijan's recognized territories by the armed forces of Armenia in early 90s caused immense suffering for Azerbaijanis over the last 3 decades, and not only Azerbaijanis, for the whole region. Fueled by Armenia's appetite for a land grab from its neighbors, lives of millions of people were affected. I am one of them. Despite the fact that Azerbaijani lands were being occupied, some Western countries, instead of providing at least some humanitarian assistance, imposed sanctions against my people. Today, some of those individuals who led the occupation campaign against Azerbaijan are facing fair trials. Time has finally come for the perpetrators of numerous war crimes answer for the actions against innocent people. As someone who lost her childhood to war and refugee camps, I, along with many others, wish that these people had been held accountable before an international criminal court sooner. The devastation they caused to the entire region is undeniable, and it's well documented in the reports of international organizations since the 90s. My country has consistently shown its commitment to peace by offering to sign a peace deal with Armenia right after war ended in 2020. And currently, Azerbaijan has undertaken major demining and reconstruction operations in the liberated territories aimed at bringing life to the once war-torn territories. And we hope unfair sanction will not hinder these processes. Thank you very much.
Thank you very much. I will just appreciate if we are staying within the topic of our discussion for this side event today and do not go beyond that. So I saw hands. So please, the floor is yours.
This is Rossi from APG 23. First of all, I would like to thank you for organizing this side event and for all the inputs by the speakers. I hope to remain in the topic, but I would like to remark as an NGO the total illegality of UCM and the devastating effects that they have in the many countries under UCM for what is concerning the implementation of the right to development, the implementation of and respect of all the other human rights, especially the economic, social, and cultural, but also the civil political rights. It has been said also in a previous side events organized by you in 2023 by the statement by the different independent experts and special rapporteurs. Now, I would like to express our concern for the current situation that we are living in the world, because there is this trend of authoritarian regimes of sovereignty intended in a very bad way, in a rising of conflicts, in a rising of humanitarian crisis. There is a big effect of UCM also on the humanitarian sector. So my appeal is really to go on in stressing this point that is very important for our world, and to have this transversal link with all the issues of the human rights, right to development, and also the 23rd agenda and the paths of the future. Thanks very much.
Thank you very much, Maria. I do not see any hands in the room. We have a request for the floor online, so I'm giving the floor to Professor Yin Zhu. We cannot hear you at the moment. So I apologize, we cannot hear you. So apologies, we are moving forwards. Are there any requests from the floor? And if not, I'm happy to give the floor to our distinguished panelists, and I would appreciate if they stay within the 2 minutes limit in their responses and follow up to our discussion today. So I'm giving the floor to Dr. Fátima Rodríguez. Please, the floor is yours.
Questions.
Well, I see we have some technical challenges. Hope that you will be able to join us, but at the moment I'm giving the floor to Mr. Svensson.
I was asked some questions by the representative of EPLO. First, on the effects of sanctions by country and subject. Obviously, there are variations, but the one that we're concerned with now is sanctions affecting lawyers. And they do have effect because lawyers operate from a home jurisdiction usually, and they're subject to that jurisdiction, even if they're doing international cases. And where criminality is raised against them, then yes, it does inhibit what they do. Secondly, are short-run sanctions effective, whereas long-run sanctions no? In general terms, yes, because countries can find routes around sanctions, but lawyers can't because of this home jurisdiction problem. The specific problem with general exemptions from sanctions for lawyers in the United Kingdom is an overall fee cap, which covers everybody involved in a case. So no individual lawyer, like one barrister, can know whether the cap is exceeded. And if it is, through no fault of the particular barrister, then criminal sanctions can flow. And that is an ambiguity, a risk built into the system. Now, things to finish with. The first is the importance in terms of principle of the right to representation, representation of one's choice, and effective representation. Secondly, it's critical, as the ambassador for Iran indicated, to have clear law. This law may be wrong because UCMs are illegal, but where there is anything that purports to be law, it should be clear. And the slides that I skated over because of time show in the UK how there is deliberate ambiguity built into the catchment of sanctions law, designed to discourage lawyers from acting, banks from providing services, carriers from carrying food and essential goods to where they must go. And all of these points are reflected in the draft principles that our Special Rapporteur has created, and I encourage you to support them.
Thank you very much, Mr. Swainston. Do we have Ms. Fátima Rodríguez online? So, Ms. Rodríguez, the floor is yours.
Yes, I totally agree with what they said. We have real difficulties in the effective legal remedies because we have imprecise law and regulations, and it's legal uncertainty. So, and the other thing that I want to say is that we have a real problem with the over-application of sanctions because it makes real difficulties in our profession. That's it. Thank you.
Thank you very much, Dr. Rodríguez. And now I'm giving the floor to Mr. Anischenko.
Thank you, Professor. Well, from my perspective as a practicing lawyer and arbitrator, first of all, I of course fully share what Michael Swainston just mentioned and the concern regarding the impact on the legal profession. But what also bothers me a lot is that because of these negative implications we are discussing, in fact, we undermine the trust in the international arbitration as a means of effective, peaceful resolution of the dispute is undermined in the eyes of the users of arbitration. And, you know, the New York Convention of 1958 is considered to be one of the remarkable successes of the United Nations in the commercial area, and it is currently signed by 172 states. But with the current status quo, and particularly with the problems and with the negative impact on the enforcement of arbitral awards, which was also mentioned in your report, we in fact undermine all those years of building this credibility of the international arbitration. And just going down to the practical users, to our clients, we more often see that they tend to prefer the state courts or even other, let's say, less legal ways to resolve their dispute rather than good old-fashioned arbitration, I would put it that way. So from that perspective, this is really what bothers and concerns me, and that is why at the Russian Arbitration Association we are really trying to preserve the reputation of arbitration. That's probably it from my side.
Thank you very much, Mr. Anischenko. I would like to thank all our distinguished panelists for the ideas they have shared. We have traditionally discussed at the OHCHR the issue of the impact of UCMs on human rights in general. And that's why I believe it's so important to have a look from the perspective of a very legalistic approach to the issue, which unfortunately clearly demonstrate that now even lawyers become victims and targets of unilateral sanctions and cannot exercise their duties properly. I would like to mention, however, that it's necessary to, although the access to justice is not limited to the access to the court only. Access to justice and access to the meaningful remedy includes multiple rights. which I reflected in the report and will not address here, but we also need to take into account that access to justice also means the right to protection. The right to protection in various bodies at the level of the UN, at the level of national courts, and the right to get remedy and hold those who violate human rights accountable and responsible for violations happening. Therefore, I would like to close this mission by saying that some of the elements we have discussed today are really reflected in the guiding principles and the commentary to the guiding principles, which have been developed with the assistance of all of you, as well as of many scholars and many legal professionals. I believe that this instrument might be used as a tool to protect human rights as an instrument which seeks not to legitimize sanctions in one way or another, but otherwise as a defense instrument for every single individual rights of whose rights are violated by unilateral sanctions, as well as rights to states. And at the very end, I'm happy to announce that the mandates start to the work now, which the mandate was requested to be done since several resolutions already, to develop guidance on right to access, meaningful remedy, accountability and responsibility and redress. And I would appreciate your assistance in this work a lot. By saying that, I would like to thank all of you who has come, as well as those who have joined us online for your presentations, with my deepest thanks to our distinguished panelists. And I would like to reiterate my openness for further cooperation. So at that point, the side event is closed. Thanks a lot. Thank you.